That was an argument that John Kennedy faced when he was running, and the joke he told afterward that had they lost, because they kept saying the Pope was going to move into the White House, the Pope's going to run things. He said, had we lost, we only had enough money to send a one-word telegram to the Pope, unpack. But you know, I asked Sonia Sotomayor about a comment she's made. She said, of course one's life experience is shaped who they are. I would hope your life experience shapes everybody in this room. But she went on to say, ultimately and completely, and those are her words, ultimately and completely, as a judge you follow the law. There's not one law for one race or another. There's not one law for one color or another. There's not one law for rich and different one for poor. There's only one law. And ultimately and completely, a judge has to follow the law, no matter what his or her upbringing might be. That's the kind of impartial judge that we want. That is respect for the rule of law. That's also the kind of judge Sonia Sotomayor has been. And I think that when she's elevated to the nation's highest court, she'll live up to Justice Thurgood Marshall's description of the work of judge. He said, in our day-to-day work, we must continue to realize we're dealing with individuals, not statistics. And I think those are important words because the court can have a fundamental impact on people's lives. Let me tell you about one case, the Lilly Ledbetter case, and you students will study this. 5 justices struck a severe blow to the rights of working families across the country. 40 years ago, Congress put in place a law to outlaw discrimination in the workplace so that men and women will receive equal pay for equal work. Now, what they did, the Supreme Court did, an activist court, a court made up of people who talked about judicial modesty and judicial restraint during their confirmation hearing. So a court that basically struck down equal pay for women. And I was very proud to be standing with Lilly Ledbetter, standing right behind President Obama, and Wade, you were there, when he signed the Lilly Ledbetter law as his first act. And that is going to change us. You know, those who care about the Constitution, we should ask whether Judge Sotomayor will act in the mold of those conservative activists on the court now who gutted legislation designed to protect Americans from discrimination in their jobs and in voting. Laws meant to guarantee the access of Americans to health care and education. Laws meant to protect the privacy of all Americans from an overreaching government. When those laws are in place and conservatives on the court strike those down, are they not being the same kind of activists they tell us to avoid? So it took the Supreme Court that understood the real world to take the seemingly fair-sounded doctrine of separate but equal. I mean, what could sound more fair? Well, in reality, of course, it was a straitjacket. It was offensive to the Constitution. It allowed segregation. And all Americans have come to respect what the Supreme Court did in Brown versus Board of Education to end this racial discrimination. But just 2 years ago, in the Seattle school desegregation course, a narrowly divided Supreme Court undercut that landmark decision, something I thought I'd never see in my lifetime. Chief Justice Roberts' opinion failed to recognize the struggle for equality that persisted long after Brown versus Board of Education. Segregation did not end with the case of Brown versus Board of Education. It may have ended de jure. It did not end de facto. And so we should always fight that. And Justice Stevens wrote in a dissent, and please read that, in the case that the Chief Justice's opinion twisted Brown versus Board in a cruelly ironic way. Justice Breyer's dissent criticized the Chief Justice's opinion as applying an overly theoretical approach to case law. And he said, law is not an exercise in mathematical logic. If it was, we wouldn't need judges. We could do it with computers. And I don't ever want to see that day. Chief Justice Warren, a man who had real life experience, took 2.5 years to put through Brown versus Board of Education, but he made sure it was going to be a unanimous decision. So a deeply divided United States of America could accept this. In contrast, the Roberts Court, in its divided desegregation decision 2 years ago, ignored the real-world experience of millions of Americans and said it would depart from the hallowed precedents of the court. In a few days, the Supreme Court will issue one of its most important decisions in years, the constitutionality of the reauthorized Voting Rights Act. Now, the Voting Rights Act provision at risk, Section 5, is a time-honored way to prevent discrimination. The court has always upheld the constitutionality of Section 5. I got to tell you, I listened to that argument in the Supreme Court, and I'm very, very worried about it. You know, students are taught that there's no more explicit grant of power to Congress than that in the 15th Amendment to allow us to protect the right to vote. Passage of the Voting Rights Act was a result of an historic struggle for our civil rights. Your dad remembers that. He remembers when it reached a crucial turning point on March 7, 1965. I was 15 years old. At that time, I was 25 years old, I'm sorry. I wish I was 15. But on the Edmund Pettus Bridge in Selma, Alabama, state troopers brutally attacked John Lewis and his fellow civil rights marchers. And if you ever have a chance to meet John Lewis, you're meeting a hero. The events of that day, now known as Bloody Sunday, were captured in newspaper photos, on television, and proved to be a catalyst. America woke up to the ugly face of segregation, and Congress passed the Voting Rights Act within months. So the Constitution's guarantees of equal access to the political process, regardless of race, would not be undermined by discriminatory practices. Now, there was a big battle to get that through, but 3 years ago, Republicans and Democrats in the Senate and the House of Representatives came together. We reauthorized this. We did this after 20 hearings in the House and the Senate. We had an overwhelming vote. President George W. Bush had a major signing ceremony on it. And now we have to worry whether the Supreme Court is going to undermine that. I said to John Lewis when we were walking out after that signing, I said, John, isn't this wonderful that we've kept this? And he said, you know, Patrick, it's wonderful not just for African Americans, it's wonderful for poor whites, it's wonderful for Hispanics, it's wonderful for all those people that the power structure might want to keep from voting. So when we consider Judge Sotomayor's nomination this summer, think what the enormous impact justices have on our freedoms and values. And whether you're from the South Bronx, or the South Side of Chicago, or South Burlington, Vermont, the American dream inspires all of us. Her life story is the American dream. Instead of having this division in the Senate, we should unite all 100 senators, because only 101 people get a voice in the appointment and the seating of a Supreme Court justice. First and foremost, the president who makes the nomination, then 100 senators who have to sit in place of 300 million Americans. We should come together. Remember what the Vermont marble over this entrance to the Supreme Court says, equal justice under law. We should get this nomination, we should confirm her, and we should guarantee equal justice under law. Thank you very, very much.